Hi everyone, my name is Joseph Fan, and I am a Cornell Law School graduate and a practicing attorney licensed in New York. The purpose of today's video is to talk to you about your rights as a protester. Now, there's no attorney-client relationship created by this video, and this is not legal advice. This is all legal information. This video is not a substitute for speaking with an attorney, and you should always consult with your own attorney. The First Amendment of the U.S. Constitution gives you the right to protest. This includes peaceful assembly and freedom of expression. There are some restrictions. For example, you can't yell fire if there's no fire in a crowded movie theater. You can't incite violence or unlawful activity. So you can't say, hey, let's all kill the police, or hey, let's all set this building on fire. You can protest in any public place, but the police or the government can restrict the time, place, manner, noise levels, or implement curfews, as long as it's non-discriminatory and not based on the content of the speech. Police can ask you to leave if there's the threat to the health or safety of the public. It must be reasonable, and there has to be a way for you to leave. So here are some things you can do while you're protesting. You can march, you can display signs, you can hand out flyers. Things that you can't do, you can't throw a brick through a window, or you can't throw a Molotov cocktail. While protesting, you shouldn't be carrying any illegal weapons or drugs. And if you're undocumented, getting arrested can clearly be more problematic. Can you videotape police in public? Yes, you have an absolute right to record in public. As long as you're not interfering with the police, you obviously shouldn't get between them, or you can be hit with an obstruction or interference charge. You can announce that you are X feet from the officer and pan toward the ground to show the distance between you and the officer. Police can tell you to stop recording, but you can reply, you are in a public place, and you believe you have a right to record. You can do this politely and calmly so they can't say that you're being aggressive. Police can try to take your phone or camera, and you shouldn't resist them. Otherwise, you might get a resisting arrest charge. But you should say, I do not consent to any searches of my phone or camera, or the deletion of anything on it. That way, the police can't claim later on that you handed your phone to them voluntarily, or that you allowed them to delete anything. You should also ask if you're free to go. Once you do this, it's clear you are not there voluntarily and the police are detaining you. They can only do this if they're able to articulate the reasonable suspicion that you are currently or about to commit a crime. Police can never delete or force you to delete videos. They can't even look at your videos without a warrant. You're actually automatically granted a copyright as soon as you create your video. This means you own the intellectual property that the video created, which means police cannot take it from you, delete it. You could choose to comply, but you don't have to. This is again why you should have cloud backup turned on your phone. And you should also live stream it so it's uploaded in real time. Specifically in New York, there is a law, the New Yorkers' Right to Monitor Act. This affirms the right of an individual to record law enforcement activity and to maintain custody of that recording and any instruments used to make that recording. Now, here are some proactive measures you can take to protect your rights. Your phone. Use a passcode, not biometrics like a thumb or face unlock, and turn on cloud backup. That way, a police officer can't force you to unlock the phone and go through your videos. What if you're arrested? First, check if you're actually under arrest. Ask, am I being detained? And if not, am I free to go? If you were arrested, were you read your rights? These are your rights, the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you can't afford one, one will be provided to you at no cost. All of this is important, and when you speak to your attorney, tell them exactly what happened from the moments right before you were placed into custody and immediately after. Once you're read your rights, you can tell the police, I am exercising my right to remain silent. I want to speak to my attorney. Then they can't keep questioning you. And if they do, you can remain silent. Police can lie to you. They can try to bargain with you or even try to have you sign a false confession. Don't do anything without your attorney present. Don't let them try to intimidate you. You have the right to remain silent. And to your attorney, exercise your rights. If you're in police custody, you might think that they're your friends or they have all this evidence on you. Police are not your friends. And again, they can lie to you. Now, you might just want to get out of there and go home. This might be a scary situation, especially if this is your first time getting arrested. They know this. They can't keep you locked up without cause, so don't say anything until you speak to your attorney. You might think, hey, will it look bad to a jury if I don't say anything at all? They'll think I'm guilty. Well, the fact that you remain silent can't be used against you. It is your right. What do you do if you're stopped by the police? Fourth Amendment of the Constitution protects you against unlawful search and seizure. There are only 4 legal ways a police officer may search you: with a warrant, exigent circumstances, like an emergency, consent, or probable cause. Probable cause meaning that there's a reasonable suspicion that you have committed, are committing, or about to commit a crime. So once you're stopped, first thing you say is, I do not consent to any searches. Am I being detained or am I free to go? If you're being detained, you can ask the police officer, what crime do you reasonably suspect me of having committed, am committing, or about to commit? The police must be able to articulate why they've detained you. If they're unable to, you gotta ask, am I under arrest or am I free to go? If you are under arrest, you can say, I am going to remain silent, and you can exercise your right. If you're not under arrest, you can go back to the top. Am I being detained or am I free to go? If a police officer stops you, do you have to give your name? Well, it depends on the stop and identify statute in your state. New York requires reasonable suspicion. Reasonable suspicion means that the officer must articulate that you were committing, are committing, or about to commit a crime. If there is a reasonable suspicion, you have to give your name, your address, and an explanation of your conduct. In New York, you don't have to carry an ID. You don't have to show an ID. But if you're issued a summons or arrested and refuse to produce an ID and or identify yourself, police can detain you until you can be identified. Do not give a false name. This is a crime. Is stop and frisk still a thing in New York? Yes. There are 2 parts to stop and frisk. The stop part. Is there a reasonable suspicion based on observable conduct and or information that someone is committing, committed, or is about to commit a crime? Is there an objective, credible reason for the stop? The second part of stop and frisk is the frisk. An officer is allowed to pat you down, frisk your outer clothing for weapons. And an officer feels objectively and reasonably that there could be a weapon, they can reach inside your clothing and determine whether or not it's a weapon.